Welcome back to For the Defense. I'm David Oscar Markus, and we have a bonus episode for you today, which strays a little bit from seasons 1 and 2, where, as you know, we spoke only to criminal defense lawyers about their most fascinating trials. Well, today we have Federal District Judge Jed Rakoff from the Southern District of New York, and although he was a previous defense lawyer and also prosecutor, he's now a sitting judge, and he has lots of interesting and unique takes on the criminal justice system. He's written about them in his new book called Why Innocent People Plead Guilty. And what I love about the book and Judge Rakoff is he makes you think. He's a thought-provoking guy. He's an interesting guy. And so I thought it would be really neat to talk to him about our criminal justice system and the problems that we've discussed throughout seasons 1 and 2 of For the Defense. I want to thank David Leibowitz for coming up with the idea to interview Judge Rakoff, and thank you to Judge Rakoff for doing this. It's not every day that you can talk to a federal judge about the criminal justice system. So let's get right to it and talk to Judge Rakoff in For the Defense next. Well, this morning I'm really excited. We have Judge Jed Rakoff on the podcast, and Judge Rakoff is a judge in New York in the Southern District of New York, and he's a former prosecutor and defense lawyer. We're not going to talk much about the former prosecutor part, but we'll talk about the former defense lawyer. As you know, there's so few defense lawyers on the bench. And so Judge Rakoff is one of the few who has actually represented a real live person. Welcome to the show, Judge.
Thanks very much. You make a very good point. When I went on the bench, I think there were maybe 2 other federal judges who had any meaningful criminal defense experience. I'm very hopeful that the Biden administration will change that number considerably.
It's really needed. And I know I'm jumping ahead here, but one of the suggestions that you had to fix some of the problems in the criminal justice system is we need people who are prosecutors to have served or will serve as criminal defense lawyers like they do in Britain.
Yes, my ideal proposal, which I doubt will ever be enacted, but I still like it, would be for every prosecutor to spend 6 months out of every 3 years as a criminal defense lawyer for indigent defendants in some other distant district, so there would be no conflict possible. And I think that would give prosecutors who, frankly, largely run the present criminal justice system much more balanced view and able to appreciate defenses and questions that they don't really appreciate now.
I want to also mention to everybody that Judge Rakoff just wrote this wonderful book, and it's called Why the Innocent Plead Guilty and the Guilty Go Free and Other Paradoxes of Our Broken Legal System. It's a wonderful book, and it's made up of essays that the judge has written over the years for the New York Review of Books. And we're going to talk a lot about this book during the podcast today, but I wanted to mention at the beginning and for everyone to get a copy. It's a great book for both prosecutors and defense lawyers alike. So I mentioned that at the beginning, but before we get to the book, Judge, I'm doing this interview at the end of March, and you just concluded a trial during COVID times, and I think this was the second one you've done, right?
Correct. I had a month-long trial in November, and then this was 3.5 weeks in March.
And I was wondering if you could just tell us how those trials went, some of the precautions you took, some of the hurdles you had to face in doing the trial, because I know a lot of judges are really interested and have been following how you did those cases.
So fortunately, my court had started planning long before COVID-19 for how we would deal with crises of all sorts, because we had gone through a period after 9/11. My courthouse is just a few blocks from 9/11, when we had to shut down the courthouse, and we wanted to avoid that in the future. And the result is that we were already well on our way to figuring out how to make the court run even during this pandemic. Our courthouse never closed at any time during the pandemic. Criminal trials, however, had to be spaced out. What we did was we took our 4 largest courtrooms and redesigned them so that the jury could be seated with 6 feet between each juror, and they would wear masks. We designed a plexiglass witness stand with a machine that takes the air out of the courtroom, so the witness could take off his or her mask and be seen and their demeanor observed. We had a similar plexiglass box for the questioner, so the questioner could take off his or her mask and have a more, if you will, direct conversation with the witness. For the jury deliberations, we took one of our smaller courtrooms and again designed it so there would be 6 feet of distance between each juror, and then 2 very large screens so they could, we would send in a computer program with all the exhibits, and they could just put them up on the screen as they chose. And frankly, that part of it, I think, maybe should be continued. I think that was a very helpful thing to the jurors. Of course, what we were most worried about was whether the jurors would be COVID scared, so to speak. And to an amazing extent, they were not. When we picked, in each case, I picked 12 jurors plus 4 alternates. And initially, almost no one raised a COVID concern. And I think the reason is because they were so dying to get out of their apartments or houses and do something interesting. But we did, in both trials, one juror tested positive for COVID-19, and one juror was exposed to a close friend who was tested positive. We had anticipated that might happen, so we took a break. Fortunately, in both cases, it occurred shortly before a weekend. And then we had arranged to have a very high-level COVID test done right at the courthouse of all the remaining jurors, and with the results available in 15 minutes after the test. And in both cases, fortunately, all the jurors tested negative, and we were able to continue with the trial. Had any of the jurors tested positive, that would have been a more problematic situation.
You know, it's interesting that the witness and the questioner were not wearing masks, because the complaint I've heard most from defense lawyers is, you know, how can you cross-examine a witness wearing a mask? And in Miami, where I'm from, in state court, trials have started up very slowly, but they don't have that booth that you were talking about. And the witness is wearing a mask, and the defense lawyers are objecting. And it seems like it would be unfair to require a cross-examination of a witness with a mask on.
Well, without expressing my opinion on any issue that might come up at some point,
of course.
As a former defense lawyer, I totally agree. I mean, it's very important for the jury to see the demeanor of the witness, and also, I think in any good cross-examination, there's a dramatic interplay between the lawyer and the witness that can only be achieved if you don't have masks. So I very much like the way we did it in my court. You might ask, did the lawyers have any trouble reading the jury?
Right.
because they were masked. So we did two things to obviate that. First, we placed the defense counsel and defendants directly facing the jurors and quite close, about 12 feet away, whereas the government was facing the judge and could not see the jury as easily. And we did that with malice aforethought because we knew that while both sides would like to read the jury, it was more important that the defense be given that opportunity. And I talked to the defense counsel after the first trial, and they said that in a trial that long, they could read the jury pretty well. The first few days, it was harder to read them than if they hadn't been wearing a mask, but these were both long trials, and they were able to read them pretty well after a week or so. The only other thing that I thought we couldn't allow the jurors to go right up to the jury bar. And I know when I was a defense counsel, I always tried to do that to try to have the, impact, if you will. And and that we couldn't do for obvious reasons. So they gave their summations from the little plexiglass box so they could be viewed and so forth.
Sure.
I didn't think it made that much of a difference, but arguably there was a little difference there.
As a just a footnote to your first trial, you had a Miamian up there, Matt Menschel.
He was terrific.
And Matt's a close friend. A funny story. When I was a federal defender, an assistant federal defender, he was a prosecutor down here, and we tried a couple of cases against each other, and we became close friends after that. I tried my second trial with him, and I didn't know what I was doing. I gave an opening, and I kind of overstated things with the jury, and my client testified, and he called me out with the client. He said, "Your lawyer kind of overstated things with the jury," and my which I started sinking in my chair. I was so embarrassed, and my client, she was great. She said, "Give Mr. Markus a break. It's his very first trial."
Well, the Mr. Menschel had not appeared before me previously. And I told this to him as well. I thought he was just terrific, a really excellent lawyer. The jury convicted nonetheless, but it was a mixed verdict. There were 2 counts against his client. They acquitted his client of the one that carried the more serious penalty and convicted on the other. Being a softie, I gave his client 1 year. So he did all right.
We're gonna talk about sentencing in a minute. He I guess he can claim credit for the acquittal, and his co-counsel can take the conviction. So that's
the way it always works, right?
That's right. I'm David Oscar Markus, and we'll be right back in For the Defense next. I'm glad Jed Rakoff recognized that Matt Menschel is a great trial lawyer. He was a really strong prosecutor, and he's a wonderful defense lawyer, someone I enjoy working with now and enjoyed trying cases against when he was a prosecutor. It's also interesting that Judge Rakoff talks about not knowing Menschel before he tried a case up there. Whenever you try a case out of town, and I love trying cases out of town, you start with a clean slate. Most judges wonder, who is this Miami lawyer coming into my district, and start with a bit of skepticism. But by the end of the trial, really appreciate good lawyering, and it's fun to try cases out of town. I remember my dad tried a case in Arizona, and the judge invited him to dinner one night with the prosecutor, and the judge and the prosecutor thought this Miami lawyer wouldn't be able to handle the spicy food. They ordered the spiciest chicken wings available, and my dad told me that he was choking on those chicken wings, but held it in because he didn't want to show any weakness to the judge or the prosecutor with the spicy food. The next day, the judge commented that he really appreciated that a Miami lawyer could handle that spicy food and respected him the rest of the way. I haven't had that experience, but it has been fun to try cases all over the place, not just in Miami. Let's get back to Judge Rakoff in For the Defense next.
Let's talk about the book. So I will say the first essay that I became aware of the book was, of course, Why the Innocent Plead Guilty. And I have to say, Judge, it caused quite a stir among both defense lawyers, prosecutors, and even judges. People in the system know it's true, although I think prosecutors and judges don't like to admit it. But people outside of the system are shocked when they hear about this phenomenon. And so I'd like to understand if you could explain the premise. Why do innocent people plead guilty? And how did that happen? How did our system get to that point?
So they plead guilty when all is said and done because they do a cost-benefit analysis and figure that they would rather take the lesser penalty than the possible much harsher penalty. And what really drives all this and drives mass incarceration as well are these very overly punitive laws that were passed in the 70s, 80s, and 90s with mandatory minimums, career offenders, and the whole business. And what does a prosecutor do? Well, in the federal system, they are obligated to charge in their indictment every crime they think they can prove beyond a reasonable doubt. And so if it's a drug case, for example, there will often be counts that will carry up to 30 or 40 years mandatory minimum because both the weight of the drugs and the use of a gun and so forth was involved, even though there were like 13 people and your guy may be, a relatively low-level guy. So your guy tells you he's innocent. When I was a criminal defense lawyer, all my clients initially told me they were innocent. And about half, some of them are telling the truth and some were not. I don't want to put statistics on it. But in any event, you go to meet with the prosecutor and you say, guilty or innocent, my guy's a schnook. Give him a break. And the prosecutor says, okay, we'll give him a 5-year count, but he's got to plead guilty in the next 2 weeks. And you say, well, I've got to investigate. Okay, I'll give you 4 weeks, but no more because I got to move on with the case. So you go back to your client and you do a little investigation and you say, there's at least one witness out there who supports your position that you weren't involved. And the client says to you, well, what are my chances if I go to trial? And you say, I can't tell you that. They're not zero, but they're certainly not 100% either. And then after thinking about it, frequently he will say, well, I'll take the plea. And in the federal system, since they don't allow Alford pleas, you say to him, well, I can't have you plead guilty if you're not guilty. Oh, yeah, I'm guilty. But maybe he is and maybe he's not. And the statistics, just to not sorry to ramble on, but
No, this is great.
The Innocence Project of the 265 people that they have now exonerated through DNA, all of which they proved had nothing to do with very serious crimes, murder and rape, most of them. 10% of those pled guilty mostly because they were facing the death penalty or life imprisonment without parole, and they wanted to get something better than that. There's also something called the National Registry of Exonerations, which traces all exonerations since I think about 1989, and it's up to 2,400, and 10% of those are people who pled guilty. So if you say, okay, maybe that's not a random sample, let's be conservative, let's take 5% as the real figure, there are 2 million people in jail. So that means there's 100,000 people right now in prison who were factually innocent of the crimes they were charged with and that they pled guilty to.
Right. And I think that's a pretty conservative number because that's factually innocent, as you say. That doesn't even address, the cases where there's a real legal challenge, where people might say the statute doesn't criminalize this, and the prosecutor says, listen, if you fight, you're not going to get the third point for acceptance. You're not going to be able to cooperate. You're not going to be able to do all these things. And so they end up not challenging the statute's coverage of their conduct. And I think there's a huge number, especially in white collar cases, which we'll talk about in a moment, where the conduct is unclear whether it's even criminal. We see Bridgegate and other cases coming out of the Supreme Court.
Absolutely right. And it would be good for the system of law for those cases to go to trial and clarify the law in those areas. And that doesn't happen. The statistics, as I'm sure you know, are that in the federal system, 97% of the defendants plead guilty, almost all pursuant to plea bargains. And it varies a little bit from state to state, but overall, it's about 98% for the states combined. So
the risks have become too high to go to trial. So even if you have a good legal challenge, even if you're factually innocent, if you were to lose a trial, you're going to get crushed by most judges.
And that's another whole thing. I made a practice, although I ended it for a reason I'll tell you in a minute. I made a practice for a few years of telling a defendant at the beginning, at the arraignment, you of course need to consider whether you want to plead guilty or go to trial. But I will tell you in advance, your sentence will be the same whichever way you go. The trouble is I couldn't really fulfill it because I was thinking of what the sentence would be if the guy pled guilty or went to trial on the things charged in the indictment.
Right.
But of course, the plea bargain was often to a much lower amount. So it was not strictly accurate, so I don't say it anymore. But I do think, this is a whole separate subject, but I think in addition to these mandatory minimums and career offender statutes, the guidelines, even though they're now discretionary, still play a very punitive role, much too punitive role.
We're going to talk about that in a moment, but I'll say this, most people ask criminal defense lawyers, at the cocktail parties, how do you represent the person who did this? And I always respond, it's much harder when the person is sitting across from me and says, listen, I didn't do it, or I want to fight. And you have to explain the risks to that person and what the system will do to that person if they have the courage to fight. That's why it's much harder, I think, as a criminal defense lawyer to have that discussion with the innocent person or the person who wants to fight. The guilty person's easy. You're going to mostly work out a deal. As you say, 98% of cases resolve themselves. So if the guilty person comes in, that person's going to end up pleading guilty. That's an easy case most of the time. It's the innocent person that's hard because you have to have those real discussions about risk reward.
Yeah, there's no question about it. And of course, the classic answer to how can you defend those people is usually we're champions of liberty. We're the ones who keep the system honest and all like that. That's very true. But it's also true that we're the only hope for the person who is actually innocent, but who looks to the public and everyone else like he was guilty. And it takes courage to be a good defense lawyer. I could never be more proud of the years I spent as a criminal defense lawyer. I really thought this is what the law is really all about.
Well, I think the law, I agree with you, of course, but I think one of the things that's so frustrating for, I think, criminal defense lawyers, and I would hope prosecutors and judges too, is that there are so few trials now. The system, as you point out in your book, used to be a system of trials. And even after most cases went to trial, even throughout the 70s and up until the guidelines, at least 20% of cases went to trial. That was a pretty good number, not great, but pretty good. Now we're at 3%. I mean, Judge, what can we do to fix this? Because it's a real problem. I think it's the reason innocent people are are in trouble. It's the reason our system is in trouble is there's no trials left. And so how do we get trials back?
The short answer is repeal all those terrible laws. I mean, that's what changed. If you look at the statistics, you'll see as each of these laws was passed, immediately there was a decrease in the jurisdiction, in the number of trials, and with the next law, it went down further. So it was a perfect correlation. So the only, in my view, the only real fix would be to repeal all these laws and bring back laws that are not nearly as punitive and not nearly as mandatory. Short of that, I get to try more trials than I'm going to brag for a second here, than any other judge in my court, and there are 40 judges in my court. And the reason is I make it clear to the defendant and his lawyer from the very outset that I am delighted if they go to trial, that I think the system benefits if they go to trial, and they shouldn't have to worry about my slamming them or anything like that. I'll give you just one example. I never apply the guideline increase for alleged perjury at trial by the defendant. I think, frankly, it's unconstitutional. I think it is it chills the right of a defendant to take the stand, because if he takes the stand, one guy, the judge sitting up there, is going to determine whether he lied or not, and on that basis will increase his penalty. So I always let counsel know there will be no penalty under the guidelines if your guy takes a stand, regardless of whether I think he's telling the truth or not.
You know, that's an important point. And I'll say this, many judges, there's lots of counts in these cases that go to trial. And if a defendant testifies and is acquitted of a bunch of counts, judges will still apply the obstruction enhancement. And I always argue to judges, well, I mean, obviously the jury believed him on a lot of stuff here, and they'll still obstruct him for testifying. It seems crazy to me.
Yeah, I learned that the hard way in my first criminal defense trial, where I got an acquittal of 18 out of 19 counts, and the judge still slammed him on number 19.
And that's another, it's another point that most people in the public do not realize. And you can be held responsible for acquitted conduct, punished for testifying. And I tell my mom these things, and she doesn't believe me. She says, no, there's no way. If you're acquitted, the judge can take that into account at sentencing. And I mean, to me, that's an easy fix, but the Supreme Court hasn't done it yet. I think Congress should fix that.
Congress definitely should fix it. The Sentencing Commission could fix some of this. I don't want to overstate that. And of course, they've been without a majority for the last 2 or 3 years, so they haven't been able to do anything. But now that can change. It totally boggles my mind that they place such emphasis on drug cases, on the weight of the drug, and such emphasis in white-collar cases on the amount of the loss.
Makes no sense.
This is a human being in front of you. You got to find out what he's like, what motivated him, there are so many factors, and yet 70% of the guideline calculation in drug cases is the weight of the drug, and 70% of the calculation in white-collar cases is the amount of the loss. And to me, that makes no sense.
It makes no sense for so many reasons. One reason is, for example, to use the loss, I mean, the numbers were sort of plucked out of thin air. Why does, if you steal $700,000, it gives you X amount of points. And if you steal $900,000, you get 2 more points. Why? I mean, there's no explanation.
And actually, that's true of the guidelines in many other respects. How do they decide 2 points for this, 3 points for that, 1 point for that? So my guess is they take little slips of paper and they say, you pick one, you pick one. Well, not really, but it's not a rational process.
So let's talk about some ideas to fix it. You have some in your book, and I'll throw out some. One idea, and we talked about this at the very beginning, is to have prosecutors sit as defense lawyers, at least for some time, as they do in Britain. And I have always said, before a prosecutor should prosecute, they should visit the jail for a couple hours, sit in a cell for a couple hours, and see before they ask for 8 years. I mean, if they would go crazy without their phone for 30 minutes, I think, if they had to sit in one of those cells.
So it's interesting because I always have my law clerks visit the federal jail, which is right across the street from my court. And I always tell the guy who gives them the tour, a fellow I've known for some years now, be sure to show him the shoe, the
right.
solitary confinement, right? Because then they'll get a sense of what jail really is like. And otherwise, by the way, when they give the tour for dignitaries and so forth, they never show them the shoe.
No, because it's scary. I mean, one of the thoughts that I've always had is that we should try to make the criminal system a little bit more like the civil system. In other words, let's have more discovery, depositions. Florida, by the way, is one of the few states that allows depositions in state court and in criminal court. And it works. You have much less Brady violations. Both sides get to see the strengths and weaknesses of the case. And it seems to work. I also think, we should have more motions to dismiss, motions for summary judgment. Of course, none of those really happen in federal criminal cases. And I think that's part of the problem.
It is really, if you were a man from Mars and you came and looked at our system, you would say, I don't understand this. In civil cases where it's just money involved, you have an unbelievable amount of discovery. In criminal cases where it's a person's liberty at stake, you have very restricted, limited discovery. It makes no sense. If you make this argument, someone on the other side will say, well, witnesses need to be protected, and they're often very nervous, and but that's handled through keeping their identity secret. I mean, there are many ways to handle that, and frankly, that never comes up in white-collar cases. It's just other kinds of cases.
I always smile when I hear those concerns brought up by prosecutors, because in cases where there is obstruction or violence, there's ways to deal with that. But what is that, in 1% of the cases, less? I mean, the vast majority of cases, witnesses aren't tampered with. If anything, the one side that can offer the witness something is the prosecution, right? They can offer them their liberty. I will say this. I don't know if you know Judge Zlock from the Southern District of Florida.
By name, but I don't know him personally.
Yeah, he's the former chief judge here, conservative guy. But he wrote an opinion called Singleton back in the early 90s. And he said, I find that the giving of prosecution witnesses their liberty, it violates the bribery statute. And he says, so in my courtroom, no more 5Ks, no more offering witnesses reductions in their sentences. Witnesses are witnesses, and neither side should be able to offer them anything. Now, of course, that got overturned by the.
I was going to say, how many nanoseconds were there before the reversal?
Right. I mean, but it, as we all know, it got reversed, but it does have some pull to it, right? Like defense lawyers can't offer a witness something, and prosecutors can not only offer them something, but offer them their liberty. It seems crazy.
As I say, I was a prosecutor before a defense counsel, and I very much like that job too. And but you don't have the same balance. A typical federal prosecutor lease is someone who's maybe 2 years out of law school. They are learning it as they do it, so to speak, but they're learning it from one side. The people they're talking to are the agents and their fellow AUSAs. And unconsciously, that makes them much more rigid than they really should be, and much less open to reasonable arguments from defense counsel and reasonable questions about their own case. Right. So it is a that I would like to see solved, but I'm not optimistic about it.
Right. Let's move to another chapter in your book, which I found fascinating, the death penalty chapter. One of the crazy facts in our system, and it seems people are willing to live with this, is that innocent people will be executed. There is no question about it. There's no debate about it. That happens. Should we tolerate a system where innocent people are executed? And I throw that softball to you, Judge, knowing that you wrote an opinion back in 2002 saying absolutely not. So tell us about that.
So that was, in many respects, one of the more difficult opinions I ever had to write. I had begun as a supporter of the death penalty, frankly, because my older brother was murdered and in cold blood. And there was a time I couldn't talk about this, but now I can. And, if you had asked me 6 months or even 5 years after that event, I would say, fry the guy. He doesn't deserve to live.
Sure.
What changed my mind was the very point you're making, that the Innocence Project using DNA, really a marvelous development, proved conclusively that there were people on death row who were factually innocent, and but for the DNA test would have unquestionably been executed. And that opened my eyes to the fact how imperfect our system can be, and how we have to make amends to account for that imperfection. And so in 2002, I held the federal death penalty unconstitutional, saying, since there is, as we now know, a meaningful possibility that someone who's sentenced to death will eventually be able to prove their innocence, it basically is a violation of due process to put them to death. And I got there through my reading of a Supreme Court case called Herrera, and I still think I read it right. That was a case where there were 4 justices on each side, and the swing vote was Justice O'Connor, who said, if you're actually innocent, it's never too late to raise that. Right. Whereas Justice Scalia, who was writing the 4-person plurality opinion, said, so we lose a few innocent people. I knew when I wrote that opinion that it would likely be reversed, because I didn't think the courts were ready for it yet. But I think slowly but surely the courts, including the Supreme Court, are moving against the death penalty. Now, the recent appointees we don't know yet,
right.
But they've cut back on the death penalty for adolescents, for persons of mental disabilities, and so forth. And Virginia, of all places,
that's right,
the heartland of the Confederacy, just did away with the death penty. So I think the long-term prognosis is good.
Although at the end of the Trump presidency, there was a rush to do some executions in the federal system.
Since as a federal judge, I shouldn't talk politics, I won't say anything about that barbarity.
Right. I mean, and the Supreme Court just granted cert in the Boston murder case from the Marathon, and that case, the First Circuit, of course, said no death penalty for him, and struck the death penalty, and the Supreme Court just took cert. So you're more optimistic than I am about it. I have concerns, and I guess my question to you, Judge, is, for your optimism, what do you think the deciding argument will be? Is it your argument that innocent people are being executed? Is it a morality argument that will have the most effect? Is it how are we going to get rid of the death penalty?
So I think the way the Supreme Court will ultimately get rid of it is this something of a charade that they use from time to time, which says every state and country in the world has concluded it's wrong. Right. And of course, except, for the 20 countries they didn't mention, or the 30 states they didn't mention. But that's right. The approach they've taken in these cruel and unusual punishment cases. But I think that's the easiest path for them to take. I still think my argument was correct, but I think Justice Breyer would vote for my argument, but I'm not sure anyone else.
Well, if I had a vote, you have mine, but I don't, unfortunately. Let's talk about one.
Oh, is that area. Right? Oh, I'm so disappointed.
Maybe one day.
You're listening to For the Defense. We'll be right back. It's just so upsetting to me that we have a system that allows for innocent people to be executed. We should applaud Jed Rakoff for trying to put an end to this. I wish more judges would take a stand. Unfortunately, it looks like the judiciary hasn't been able to stop innocent people from being executed. So what are we to do? Well, there's a wonderful institution called the Innocence Project, run by Barry Scheck. And Barry Scheck and the Innocence Project stops innocent people from being executed. And so I would urge everyone who's interested in stopping that from happening from donating and getting active in the Innocence Project. It's a wonderful, wonderful group. In any event, let's get back to Judge Rakoff and other issues with our criminal justice system in For the Defense. Next.
I'll talk about one area that I disagree with you on, and that is in your book, you talk about going after more high-level executives. Now, it's interesting to me that you say that, because you do acknowledge, of course, that we have this mass incarceration problem, and yet you call for more prosecutions of high-level executives. So why is that?
Well, for several reasons. The first is, I think any realistic view of the American legal system is that we have one law for the rich and another law for the poor. Our law for the poor is very punitive. Our law for the rich is lenient to the point of almost non-existence. So that's a problem right there. Secondly, when major financial frauds are accomplished, they bring much greater pain and suffering than the guy who just robs a bodega or something like that. These are crimes that lead to huge losses, unemployment, you name it. And back in the day, the Department of Justice used to go after the people who actually were responsible for those crimes, like the CEOs of Enron and WorldCom and Tyco. All of them were prosecuted rather than the companies, because it was they who made the final decisions to commit those crimes. Now, the Department of Justice, and this goes back now about 20 years, both Democrats and Republicans, they take the easy way out. It takes 2 or 3 years to make those cases against CEOs. You can make a case against a company in no time at all, at least in the federal system, because the federal system has automatic respondeat superior. So if the janitor committed a crime, but he did it for the benefit of the company, right, it's imputed to the company. So you got the company, by the short, what you do is you work out a plea bargain. If you think the company is not that bad, you give them a deferred prosecution. If you think the company is bad, you get a great big fine. You hold your press conference, and the person who actually committed the crime gets off totally scot-free. And that doesn't seem right to me.
No, I agree with that, of course. If the person who committed the crime, they shouldn't get off scot-free. They should be punished, obviously. But I see the problem as trying to prove that a certain executive did what he did with bad intent. In other words, he wanted to cause X and so to happen, or he did whatever he did with some criminal intent. I find, at least in my experience, that most executives aren't there trying to figure out how to do something with bad purpose. They're really good people, most by and large, and so that's
especially those that pay your bills.
Absolutely, those are the best ones, of course. Those are the best ones, of course.
So here's what I think about that. Every case is different.
Of course.
I represented a number of high-level white-collar individuals, and I know exactly what you're saying. These were not bad people. But very, very often they became aware of the misconduct that was going on. And that was the moment of truth when they chose to go along with it. They were in a position to stop it. They chose not to do so. There's, in the financial crisis that led to the Great Recession a few years ago, the CEO of Citibank gave testimony in a congressional hearing, and he basically said, when the music is playing and everyone's dancing, it's very hard to say stop the music. And that's, I think, exactly what the situation was for many higher level people. So yes, were they evil crooks of a mob sort? No, but they made a conscious decision not to stop the fraud that was going on, and that's a crime.
Senator Warren has obviously been a big proponent of going after more executives, and one of her platforms when she was running for president was we should lower the mens rea requirement for executives to make it gross negligence, so that if they should have known what was going on, or if they were negligent about what was going on, they should be held criminally responsible. I think that's a disaster.
I don't agree. I'm an admirer of Senator Warren in many respects, but I don't agree with that. I teach first year criminal law at Columbia Law School, and the first thing we learn is mens rea, and it's all about applied morality. If the guy consciously chose to do something wrong, he goes to prison. If he consciously thought he was doing the right thing, he gets off. And if he was negligent, you sue him civilly. Or the SEC, for example, in securities cases can impose, limitations on his ability to be a stockbroker or the like. Those are penalties that fit the situation.
I wonder, you talk about how we used to go after folks like the head of Enron and so on, and then we stopped. Are things getting better again? Has the pendulum started to swing back, or are we still in this, let the executives go and go after the company stage?
I haven't seen much indication the pendulum has swung back. It was beginning to swing back at the very end of the Obama administration when Sally Yates, who I'm also a big fan of, came out with the so-called Yates Memorandum, saying, in effect, give us your individuals. But then the Trump administration came along and that became a dead letter. I haven't seen the one exception is you do see in cases brought against foreign entities, often the individuals are named. That's something of a charade too. The likelihood that you'll ever get those people is about zero, but might as well throw it in because it looks good.
So the paradox that I see is that, yes, go after more executives, but your sentencings of executives are things that criminal defense lawyers embrace. I point to Richard Adelson, the COO of Empath. You wrote a sentencing opinion in that case that every criminal defense lawyer cites in every sentencing memo, which is that sentencing is the most sensitive and difficult task for a judge. And you called the sentencing guidelines patently absurd on their face and that they've run amok. And you ended up sentencing the executive to 3.5 years. Now, prosecutors say, well, that's not enough of a penalty. It's not enough of a deterrent. So how do you respond to those prosecutors?
So there are several responses. First, by the way, the guideline in that case was life imprisonment. I mean, just crazy. Another evidence of how bad the guidelines are. The government wanted a measly 20 years. Every study that I've seen by criminologists suggests that very modest sentences can have full deterrent effect in white-collar cases. Now, I want to be cautious there because it's very hard to measure this kind of thing, and a responsible criminologist will always have in their preface something about, we looked at the following 14 factors, but there may be, 10 others out there that we just couldn't measure. Nevertheless, all those studies go one way. They all suggest that modest penalties could do the job. There's also something that was well established 100 years earlier, which is that the biggest deterrent is catching someone quickly.
That's right.
But putting that aside, I've been on the bench 25 years now. I was 13 when I went on, and I have not seen any recidivism on the part of any of the white-collar defendants, not even a violation of supervised release by any of the white-collar defendants I sentenced.
Interesting.
So I take that as some confirmation, if you will, that short sentences can do the job in white-collar cases.
Those criminologists say basically that it's not the amount of time that deters, it's the fact that they got time. So especially for white collar offenders, by the way, if they get some prison time, that typically deters both specific and general deterrence, by the way. It's not the 20-year sentence, right?
Yeah.
Right.
And going back to your earlier point, that's another reason why it's important to go after high-level executives, because it has a deterrent effect that no going after the company can serve. If you are someone who is faced with the difficult decision, all my folks are committing what I now think of as a fraud. Should I stop the music? Should I turn them in? Or should I go along with it? And you hear that John Jones got a year for failing to stop the music. That I think is much greater deterrent than when you read in the paper that John Jones' company paid $1 billion fine.
Right. No, that's certainly true. I want to talk real quick. This I don't think you discussed this in your book. If you did, I missed it. But I think this is just so wonderful, which is when you sat by designation on the Ninth Circuit on the Salmon case, and you created a split with the Second Circuit on insider trading and what was required, and you ended up being vindicated in the Supreme Court. So you got some payback with the Second Circuit. Can you tell us about that?
Well, first of all, of course, I have the greatest respect for the Second Circuit. You hear that, bosses?
Yeah.
But I was very privileged. The Ninth Circuit has been kind enough to invite me to sit there on a number of occasions. And this was totally a fluke. The Newman case had come down the Second Circuit, making it much more difficult to go after insider traders, and more to the point, in my view, going well beyond what the law required, and really making criminal law, which is something that judges are not supposed to do. And and then I was sitting there in the Ninth Circuit, and lo and behold, the same issue came up, and it was totally a fluke. And the chief judge of the panel I was sitting on asked me to write the opinion. I wasn't unhappy about that, but and it did create a split, and it went to the Supreme Court, and they affirmed my opinion and rejected the Second Circuit's opinion 8-0. And my only regret is there was one vacancy on the court because I wanted 9-0.
Now you need to get on the Ninth Circuit when they have a death penalty case come up and get vindication there as well.
We'll see what it'll be like when the Supreme Court reverses that opinion 9-0.
So this has been really wonderful, Judge. I enjoy speaking about these issues, and it's great to have you on. I want to talk about one last thing before we sign off, which is you've talked about music and dancing. Your hobby is ballroom dancing, and I find that wonderful. So tell us about that. You're a ballroom dancer?
So this began about 15 years ago when my oldest daughter was getting married, and my wife said to me, they'll ask the parents of the bride to do a dance. And I said, yeah. And she said, are you going to embarrass me again with your dancing?
I love it. I love it.
My wife is not always subtle. And so I said, all right, we'll take a couple of lessons. And then I really got into it. And one of the reasons I got into it is that I have such a beautiful partner in my wife. So we now go dancing, or even during the pandemic, we've been doing remote dancing twice a week.
Wonderful.
And we enjoy it greatly. I recommend it highly. We're working right now on the Argentine tango, which is a very difficult dance for the woman and not so difficult for the man. So I like that. But the main thing, as with all tangos, is the woman has to give her male partner a look of utter disdain. And my wife has mastered that completely.
When they get Dancing with the Stars, the Judges edition, we got to get you on the show.
There we go. Now you're talking about my life dream. But
I'll tie it up with one quick story. I had a trial from the 2008 era. It was of course brought like 9 years later, right before the statute ran, for a woman charged with mortgage fraud. She had the courage to go to trial. She is a ballroom dancer in her spare time, and she went to trial and won. And she sends me pictures from ballroom dancing from time to time. So we have ballroom dancing, mortgage fraud trials, everything wrapped into one. So I thought I'd tell you that.
I think you need to expand your horizons and start some ballroom dancing.
I might have to. I have two left feet, but if in my spare time, I'll need to try it out.
I had two left feet, but it can still be done.
Judge, thank you so much for doing this. I really loved it and learned a lot, and I appreciate you taking the time with us.
It was totally my pleasure. Thanks a lot.
Well, I hope you enjoyed this bonus episode as much as I did. It's so interesting to me to speak to a judge and hear the perspective of a federal judge on sentencing, on innocent people pleading guilty, on the death penalty, and so on. There's so much more in his book. You should check it out. I'm in the process of planning season 3 now. So if you liked season 1 and 2 and liked the bonus episode, make sure you leave a review, subscribe so we can get that in as much as we can to get momentum for season 3. I also appreciate your feedback, your comments. Email me at dmarcus@marcuslaw.com. And we'll catch you in a few months for season 3 and For the Defense. I look forward to it. Thanks so much for listening.